I want you to think about something for me right now. Think about where your will is, not what's in it, not who you named, not when you signed it, just where it is, right now, this second. Can you picture it? Is it in a filing cabinet in your spare bedroom? Is it in a desk drawer in your home office? Is it in a safe deposit box at the bank that your kids don't have a key to? Is it in a folder somewhere in a closet next to old tax returns and Christmas cards from 2014? Or maybe you're not even sure. Maybe you signed it 5 years ago, maybe 10, and you know it exists somewhere in your house, but you couldn't put your hands on it right now if your life depended on it. Here's the thing, your life doesn't depend on it. Your family's life depends on it. And if that will is sitting in a drawer collecting dust, unchanged, unreviewed, and unfound by the people who are going to need it most, then I need to tell you something that nobody else is going to say to you this clearly. Your family is going to pay for that. Not in some abstract, theoretical way. In real dollars. In real time. In real relationships that break and never get put back together. I know this because I watched it happen. I didn't just read about it. I lived it. My name is Harold. I'm 63 years old. I'm a retired general contractor from Scranton, Pennsylvania. I spent 38 years building and renovating homes in northeastern PA. I'm not a lawyer. I'm not a financial advisor. I don't sell anything. I'm just a man who watched his family get destroyed because his father never made a plan. And then I spent the next 7 years educating myself so that the same thing would never happen to my kids. My father's name was Frank. He was 81 when he died in 2016. He was a good man, one of the best men I've ever known. He worked hard every day of his life. He kept his house in order. He mowed his lawn. He paid his bills on time. He fixed things when they broke. He was the kind of man who shook your hand and looked you in the eye, and you knew his word meant something. But Frank never made a will. He never set up a trust. He never signed a power of attorney. He never wrote down what he wanted to happen to his house, his savings, his belongings, any of it. He just assumed his kids would figure it out. He assumed that love would be enough to sort through the details. And I understand why he thought that. Because when you're alive and healthy and sitting at your kitchen table drinking coffee on a Tuesday morning, the idea that your family could fall apart over money and paperwork feels impossible. It feels like something that happens to other families, difficult families, greedy families, not your family, not the family you raised. Not the kids you coached in Little League and drove to school and taught to ride bikes and sat with at Thanksgiving for 40 years straight. But it happened to us, and it can happen to yours. After my father died, everything he owned went into probate. For those of you who don't know what probate is, let me explain it in plain English. Probate is the legal process where a court decides what happens to your stuff after you die. If you have a will, the court uses your will as a guide. If you don't have a will, the court uses your state's default laws, which may have nothing to do with what you actually wanted. Either way, the court is involved. Either way, there are lawyers and fees and paperwork and waiting. My father didn't have a will, so the state of Pennsylvania made every decision for us, and the process took 2 years. 2 years of court dates and attorney fees and paperwork and phone calls and arguments. 2 years where the house I grew up in, the house my father built with his own hands, sat in legal limbo while my sister Diane and I fought over what to do with it. And I want to be very clear about something. Diane is not a bad person. I am not a bad person. We didn't fight because we're greedy or selfish or broken. We fought because there was no plan. There was no document that said this is what Dad wanted. So every single decision became an argument. What do we do with the house? How do we split the savings? Who gets the truck? Who pays for Mom's care? And there was a bank account, $14,000. That was the amount in my father's checking account when he died, $14,000. And that bank account became the thing that ended my relationship with my sister. We haven't spoken since. Not because of $14,000, because of the anger and the confusion and the accusations that built up over 2 years of having no direction and no plan, and no voice from our father telling us what he wanted. $14,000, and I lost my sister. Now let me tell you something that made it even worse. After all of that, after the probate and the fighting and the silence between Diane and me, I had to deal with my mother, Ruth. She's 84 now. She's in assisted living. But back then she was still in the house, still living on her own, still thinking everything was fine. And it wasn't fine. Because nobody, not my father, not any lawyer, not any advisor, nobody had set up a trust to protect her assets from long-term care costs. When it became clear that Mom needed more help than she could get at home, we looked into assisted living facilities, and the costs were staggering, anywhere from $4,000 to $8,000 a month depending on the level of care. And Medicaid, which is the government program that helps pay for long-term care, Medicaid has rules, strict rules. One of the biggest ones is the 5-year look-back. In plain English, that means Medicaid looks at everything you've done with your money and your assets in the last 5 years before you applied. If you gave money away, if you transferred your house to your kids, if you moved assets around to try to qualify, they will find it and they will penalize you for it. The time to protect those assets is years before you ever need care, not months, years. And nobody told my father that. Nobody sat him down and said, "Frank, let's set up a Medicaid asset protection trust now, while you're healthy, while there's time, so that Ruth is protected if something happens." If we had done that 5 years earlier, Mom wouldn't have lost a dime. But we didn't, because nobody told us, and we almost lost everything. I got it sorted out eventually. I found an elder law attorney, a real one, not a general practice lawyer, but someone who specializes in exactly this kind of thing. And we got a trust set up for Mom. But it was almost too late. The window was almost closed. And the stress of that, on top of everything else, on top of the probate and the fighting with Diane and the grief of losing my father, that stress nearly broke me. I sat at my kitchen table one night after everyone was asleep, and I made myself a promise. I said, what happened with Dad ends with me. My kids will never go through this. My wife, Linda, will never be in the position my mother was in. I am going to learn everything there is to know about wills and trusts and probate and power of attorney and health care directives and beneficiary designations and every single piece of paper that stands between my family and a disaster. And I did. I read books. I went to free seminars at the library. I sat down with elder law attorneys and asked every question I could think of. I learned things that shocked me, things that most people don't know, things that most lawyers won't volunteer unless you ask. And the biggest thing I learned, the thing that keeps me up at night when I think about all the people out there who are making the same mistake my father made, is this: having a will is not enough. I know that sounds crazy. Everyone tells you to get a will. Your financial advisor tells you. Your doctor's office has a pamphlet about it. Your kids tell you. And they're not wrong. Having a will is better than having nothing. But a will by itself, sitting in a drawer, unchanged for 10 years, with no trust behind it, no updated beneficiary designations, no power of attorney, no health care directive, that will is a ticking time bomb, and your family is going to be the one standing there when it goes off. Let me tell you what actually happens when someone dies with just a will and nothing else. First, the will goes to probate court. That's right. A will does not avoid probate. Most people think it does. Most people think the whole point of a will is to keep your family out of court. It's not. A will is a set of instructions for the court. The court still has to validate it. Your family still has to hire an attorney. They still have to file paperwork. They still have to wait months, sometimes years. They still have to pay fees that can run into thousands of dollars depending on the size and complexity of your estate. Everything becomes public record. Anyone can look up what you owned and who you left it to. There is no privacy. There is no speed. There is no simplicity. Second, if your will is old and outdated, it might reference things that no longer exist. A house you sold, a bank account you closed, a person who has already passed away. And when there are contradictions or gaps in a will, that's when families start fighting. Because now there's ambiguity. And ambiguity in a legal document when emotions are high and money is involved is gasoline on a fire. Third, your will does not cover everything you own. This is the one that gets people every time. Your 401k, your IRA, your life insurance policy, your bank accounts with payable on death designations, those assets do not follow your will. They follow the beneficiary forms you filled out when you opened those accounts. And if you filled those forms out 20 years ago and never updated them, the wrong person might get your money. Your ex-spouse, a deceased parent, your estate instead of your kids, and there is nothing your will can do about it. The beneficiary form wins every single time. Fourth, if you become incapacitated before you die, your will is completely useless. A will only takes effect after you're dead. If you have a stroke, if you get dementia, if you're in an accident and you can't speak or make decisions, your will does nothing for you. Nothing. If you don't have a durable power of attorney naming someone to handle your finances, your family has to go to court and petition for guardianship. That process is expensive, it's slow, it's invasive, and it strips you of your legal rights. And if you don't have a healthcare directive, your doctors don't know what you want. They don't know if you want to be kept on life support. They don't know if you want aggressive treatment or comfort care. And your family is left standing in a hospital hallway making impossible decisions with no guidance and no authority. I watched this happen to a neighbor of mine, good man, his name was Ed, 72 years old, had a will that he made when he was 55, never updated it, never set up a power of attorney, never did a health care directive. Ed had a stroke on a Saturday morning. He survived, but he couldn't speak, couldn't make decisions, couldn't manage his finances. His wife, Helen, had no legal authority to access their accounts. She couldn't pay the mortgage. She couldn't pay the medical bills. She couldn't sell the car or refinance the house or make any financial decision on his behalf. She had to hire a lawyer and go to court and petition for guardianship of her own husband. It took 4 months. 4 months where the bills piled up and the stress nearly killed her too. And the whole time, Ed's will sat in a drawer in their bedroom, perfectly signed, perfectly notarized, completely and totally useless. When Linda and I finally got our act together, when we sat down with an elder law attorney and built a real estate plan, I felt something I hadn't felt since before my father died. I felt like my family was safe. Not because we were rich. We're not rich. I was a contractor. Linda was a school librarian. We're regular people with a regular house and regular savings. But we have a revocable living trust that owns our assets and avoids probate entirely. We have durable powers of attorney so that if something happens to one of us, the other can step in immediately without going to court. We have healthcare directives that spell out exactly what we want if we can't speak for ourselves. We have updated beneficiary designations on every account we own. Michael knows where every document is. He's our executor and our successor trustee. Sarah knows the plan too. We sat them both down at the kitchen table and walked them through everything. Not just the legal stuff, the personal stuff. Where we want to be buried, what hymns we want at the service, who gets Linda's mother's ring, who gets my father's watch. We talked about all of it, And you know what happened? Nobody cried, nobody argued, nobody squirmed. They thanked us. Michael said, "Dad, this is the most important thing you've ever done for us." And that hit me harder than I expected, because I thought about my own dad and how he never had that conversation with me and Diane, and how different everything could have been if he had. I review our plan every single January. Linda and I sit at the kitchen table with our coffee and we go through everything. We check the names, we check the numbers. We make sure it all still reflects our lives as they are right now. Not as they were 5 years ago, as they are today. It takes about an hour. Sometimes we call our attorney with a question. Sometimes we don't need to. But we do it every year because a plan that sits in a drawer and never gets touched is barely better than no plan at all. If you're over 60 and your will is in a drawer right now, I need you to hear me. That document is not protecting your family. It might be giving you a false sense of security that's actually more dangerous than having nothing. Because at least when you have nothing, you know you're exposed. When you have a will in a drawer, you think you're covered, and you're not. Pull it out this week. Read it. Is it still accurate? Does it name the right people? Does it reflect what you own today? Have your beneficiary designations been updated? Do you have a power of attorney, a health care directive? Does your family know where everything is? Does your executor know they're your executor? If the answer to any of those questions is no, call an elder law attorney this week. Not a general practice lawyer, not your cousin who passed the bar, not a website. A real elder law attorney who handles estates and trusts and probate every single day. Sit down with them and build a real plan. And then sit your family down at the kitchen table and tell them everything. Where the documents are, what your wishes are, who's in charge, what you want and what you don't want. That conversation is the most important thing you will ever do for the people you love. More important than the money you leave them. More important than the house. More important than any inheritance. Because the conversation is what prevents the fighting. The conversation is what prevents the confusion. The conversation is what keeps your family together after you're gone. My dad never had that conversation, and his family paid for it. I'm telling you this because I wish someone had told him. I'm not a lawyer. I'm a retired contractor from Scranton who built houses for 38 years. The only thing I ever knew how to draft was a floor plan. But I learned this stuff the hard way, and I'm sitting here telling you so that you don't have to learn it the way I did. This isn't about money. This is about not leaving a mess for the people you love. I'm Harold, and I'll see you in the next one.